18. Chapter IV Duties, Powers and Functions of Commission. Duties of Commission. 18. Subject to the provisions of this Act, it shall be the duty of the Commission to eliminate practices having adverse effect on competition, promote and sustain competition, protect the interests of consumers and ensure freedom of trade carried on by other participants in markets in India, provided that the Commission may, for the purpose of discharging its duties or performing its functions under this Act, enter into any memorandum or arrangement with the prior approval of the central government, with any agency of any foreign country. Inquiry into certain agreements and dominant position of enterprise. 19. 1. The Commission may inquire into any alleged contravention of the provisions contained in subsection 1 of Section 3 or subsection 1 of Section 4 either on its own motion or on 29. Receipt of any information, in such manner and, accompanied by such fee as may be determined by regulations, from any person, consumer or their association or trade association, or, b. a reference made to it by the central government or a state government or a statutory authority. 2. Without prejudice to the provisions contained in subsection 1, the powers and functions of the Commission shall include the powers and functions specified in subsections 3 to 7. 3. The Commission shall, while determining whether an agreement has an appreciable adverse effect on competition under Section 3, have due regard to all or any of the following factors, namely, a. Creation of barriers to new entrants in the market, b. Driving existing competitors out of the market, c. Foreclosure of competition by hindering entry into the market, d. Accrual of benefits to consumers, e. Improvements in production or distribution of goods or provision of services, or f. Promotion of technical, scientific and economic development by means of production or distribution of goods or provision of services. 29 subs. By Competition Amendment Act 2007 for receipt of a complaint.
19.4. The Commission shall, while inquiring whether an enterprise enjoys a dominant position or not under Section 4, have due regard to all or any of the following factors, namely, a. Market share of the enterprise, b. Size and resources of the enterprise, c. Size and importance of the competitors, d. Economic power of the enterprise including commercial advantages over competitors, e. Vertical integration of the enterprises or sale or service network of such enterprises, f. Dependence of consumers on the enterprise, g. Monopoly or dominant position whether acquired as a result of any statute or by virtue of being a government company or a public sector undertaking or otherwise, h. Entry barriers including barriers such as regulatory barriers, financial risk, high capital cost of entry, marketing entry barriers, technical entry barriers, economies of scale, high cost of substitutable goods or service for consumers, I. Countervailing buying power, j. Market structure and size of market, k. Social obligations and social costs, I. Relative advantage, by way of the contribution to the economic development, by the enterprise enjoying a dominant position having or likely to have an appreciable adverse effect on competition, m. Any other factor which the Commission may consider relevant for the inquiry. 5. For determining whether a market constitutes a relevant market, for the purposes of this Act, the Commission shall have due regard to the relevant geographic market and relevant product market. 6. The Commission shall, while determining the relevant geographic market, have due regard to all or any of the following factors, namely, a. Regulatory trade barriers, b. Local specification requirements, c. National procurement policies, d. Adequate distribution facilities, e. Transport costs, f. Language, g. Consumer preferences, h. Need for secure or regular supplies or rapid after-sales services. 27. The Commission shall, while determining the relevant product market, have due regard to all or any of the following factors, namely, a. Physical characteristics or end use of goods, b. Price of goods or service, c. Consumer preferences, d. Exclusion of in-house production, e. Existence of specialized producers, f. Classification of industrial products. Inquiry into combination by Commission. 20. 1. The Commission may, upon its own knowledge or information relating to acquisition referred to in Clause A of Section 5 or acquiring of control referred to in Clause B of Section 5 or merger or amalgamation referred to in Clause C of that section, inquire into whether such a combination has caused or is likely to cause an appreciable adverse effect on competition in India, provided that the Commission shall not initiate any inquiry under this subsection after the expiry of 1 year from the date on which such combination has taken effect. 2. The Commission shall, on receipt of a notice under subsection 2 of Section 630****, inquire whether a combination referred to in that notice or reference has caused or is likely to cause an appreciable adverse effect on competition in India. 3. Notwithstanding anything contained in Section 5, the central government shall, on the expiry of a period of 2 years from the date of commencement of this Act and thereafter every 2 years, in consultation with the Commission, by notification, enhance or reduce, on the basis of the wholesale price index or fluctuations in exchange rate of rupee or foreign currencies, the value of assets or the value of turnover, for the purposes of that section. 4. For the purposes of determining whether a combination would have the effect of or is likely to have an appreciable adverse effect on competition in the relevant market, the Commission shall have due regard to all or any of the following factors, namely, a. Actual and potential level of competition through imports in the market. B. Extent of barriers to entry into the market. C. Level of combination in the market. 30. The words, or upon receipt of a reference under subsection 1 of Section 21 inches omitted by Competition Amendment Act, 2007. 21d. Degree of countervailing power in the market. E. Likelihood that the combination would result in the parties to the combination being able to significantly and sustainably increase prices or profit margins. F. Extent of effective competition likely to sustain in a market. G. Extent to which substitutes are available or are likely to be available in the market. H. Market share, in the relevant market, of the persons or enterprise in a combination, individually and as a combination. I. Likelihood that the combination would result in the removal of a vigorous and effective competitor or competitors in the market. J. Nature and extent of vertical integration in the market. K. Possibility of a failing business. I. Nature and extent of innovation. M. Relative advantage, by way of the contribution to the economic development, by any combination having or likely to have appreciable adverse effect on competition. N. Whether the benefits of the combination outweigh the adverse impact of the combination, if any. Reference by statutory authority 21. 1. Where in the course of a proceeding before any statutory authority an issue is raised by any party that any decision which such statutory authority has taken or proposes to take is or would be contrary to any of the provisions of this Act, then such statutory authority may make a reference in respect of such issue to the Commission. 31. Provided that any statutory authority may, suo motu, make such a reference to the Commission. 32. 2. On receipt of a reference under subsection 1, the Commission shall give its opinion, within 60 days of receipt of such reference, to such statutory authority which shall consider the opinion of the Commission and thereafter, give its findings recording reasons therefore on the issues referred to in the said opinion. 31. Ins. By Competition Amendment Act, 2007 32 subs. By Competition Amendment Act, 2007 4. On receipt of a reference under subsection 1, the Commission shall, after hearing the parties to the proceedings, give its opinion to such statutory authority which shall thereafter pass such order on the issues referred to in that subsection as it deems fit, provided that the Commission shall give its opinion under this section within 60 days of receipt of such reference. 2233 Reference by Commission 3421A. 1. Where in the course of a proceeding before the Commission an issue is raised by any party that any decision which the Commission has taken during such proceeding or proposes to take, is or would be contrary to any provision of this Act whose implementation is entrusted to a statutory authority, then the Commission may make a reference in respect of such issue to the statutory authority, provided that the Commission may, suo motu, make such a reference to the statutory authority. 2. On receipt of a reference under subsection 1, the statutory authority shall give its opinion, within 60 days of receipt of such reference, to the Commission which shall consider the opinion of the statutory authority, and thereafter give its findings recording reasons therefore on the issues referred to in the said opinion. 35 Meetings of Commission 3622. 1. The Commission shall meet at such times and places, and shall observe such rules and procedure in regard to the transaction of business at its meetings as may be provided by regulations. 2. The chairperson, if for any reason, is unable to attend a meeting of the Commission, the senior-most member present at the meeting, shall preside at the meeting. 3. All questions which come up before any meeting of the Commission shall be decided by a majority of the members present and voting, and in the event of an equality of votes, the chairperson or in his absence, the member presiding, shall have a second or casting vote, provided that the quorum for such meeting shall be 3 members. 33 Ins. By the Competition Amendment Act, 2007 34 Ins. By the Competition Amendment Act, 2007 35 subs. By the Competition Amendment Act, 2007 4, Benches of Commission, 36 subs. By the Competition Amendment Act, 2007 4, 1. The jurisdiction, power and authority of the Commission may be exercised by benches thereof. 2. The benches shall be constituted by the chairperson and each bench shall consist of not less than 2 members. 3. Every bench shall consist of at least 1 judicial member. Explanation. For the purposes of this subsection, judicial member means a member who is, or has been, or is qualified to be, a judge of a high court. 4. The bench over which the chairperson presides shall be the principal bench and the other benches shall be known as the additional benches. 5. There shall be constituted by the chairperson 1 or more benches to be called the mergers bench or mergers benches, as the case may be, exclusively to deal with matters referred to in sections 5 and 6. 6. The places at which the principal bench, other additional bench or mergers bench shall ordinarily sit, shall be such as the central government may, by notification, specify. 2337 Prior to omission, section 23 read as under. Distribution of business of commission amongst benches. 1. Where any benches are constituted, the chairperson may, from time to time, by order, make provisions as to the distribution of the business of the commission amongst the benches and specify the matters which may be dealt with by each bench. 2. If any question arises as to whether any matter falls within the purview of the business allocated to a bench, the decision of the chairperson thereon shall be final. 3. The chairperson may I. Transfer a member from one bench to another bench, or e. Authorize the members of one bench to discharge also the functions of the members of other bench, provided that the chairperson shall transfer, with the prior approval of the central government, a member from one bench situated in one city to another bench situated in another city. 4. The chairperson may, for the purpose of securing that any case or matter which, having regard to the nature of the questions involved, requires or is required in his opinion or under the rules made by the central government in this behalf, to be decided by a bench composed of more than 2 members, issue such general or special orders as he may deem fit. 38 Prior to omission section 24 read as under. Procedure for deciding a case where members of a bench differ in opinion. If the members of a bench differ in opinion on any point, they shall state the point or points on which they differ, and make a reference to the chairperson who shall either hear the point or points himself or refer the case for hearing on such point or points by one or more of the other members, and such point or points shall be decided according to the opinion of the majority of the members who have heard the case, including those who first heard it. 39 Prior to omission, section 25 read as under. Jurisdiction of bench. An inquiry shall be initiated or a complaint be instituted or a reference be made under this act before a bench within the local limits of whose jurisdiction, 8. The respondent, or each of the respondents, where there are more than one, at the time of the initiation of inquiry or institution of the complaint or making of reference, as the case may be, actually and voluntarily resides, or carries on business, or personally works for gain, or b. Any of the respondents, where there are more than one, at the time of the initiation of the inquiry or institution of complaint or making of reference, as the case may be, actually and voluntarily resides or carries on business or personally works for gain, provided that in such case either the leave of the bench is given, or the respondents who do not reside, or carry on business, or personally work for gain, as aforesaid, acquiesce in such institution, or c. The cause of action, wholly or in part, arises. Explanation. A respondent, being a person referred to in subclause E or subclause B or subclause B or subclause B of clause 1 of section 2, shall be deemed to carry on business at its sole or principal place of business in India or at its registered office in India or where it has also a subordinate office at such place. 3723. Omitted by the Competition Amendment Act, 2007 3824. Omitted by the Competition Amendment Act, 2007 3925. Omitted by the Competition Amendment Act, 2007. 2440 Procedure for inquiry under Section 1941(26). 1. On receipt of a reference from the central government or a state government or a statutory authority or on its own knowledge or information received under Section 19, if the Commission is of the opinion that there exists a prima facie case, it shall direct the Director General to cause an investigation to be made into the matter, provided that if the subject matter of an information received is, in the opinion of the Commission, substantially the same as or has been covered by any previous information received, then the new information may be clubbed with the previous information. 2. Where on receipt of a reference from the central government or a state government or a statutory authority or information received under Section 1940 subs. By Competition Amendment Act, 2007 4, Procedure for inquiry on complaints under Section 19 41 subs. By Competition Amendment Act, 2007 4, Procedure for inquiry on complaints under Section 19(1) on receipt of a complaint or a reference from the central government or a state government or a statutory authority or on its own knowledge or information. Under Section 19, if the Commission is of the opinion that there exists a prima facie case, it shall direct the Director General to cause an investigation to be made into the matter. 2. The Director General shall, on receipt of direction under subsection 1, submit a report on his findings within such period as may be specified by the Commission. 3. Where on receipt of a complaint under Clause A of subsection 1 of Section 19, the Commission is of the opinion that there exists no prima facie case, it shall dismiss the complaint and may pass such orders as it may deems fit, including imposition of costs, if necessary. 4. The Commission shall forward a copy of the report referred to in subsection 2 to the parties concerned or to the central government or the state government or the statutory authority, as the case may be. 5. If the report of the Director General relates on a complaint and such report recommends that there is no contravention of any of the provisions of this Act, the complainant shall be given an opportunity to rebut the findings of the Director General. 6. If, after hearing the complainant, the Commission agrees with the recommendation of the Director General, it shall dismiss the complaint. 7. If, after hearing the complainant, the Commission is of the opinion that further inquiry is called for, it shall direct the complainant to proceed with the complaint. 8. If the report of the Director General relates on a reference made under subsection, and such report recommends that there is no contravention of the provisions of this Act, the Commission shall invite comments of the central government or the state government or the statutory authority, as the case may be. On such report and on receipt of such comments, the Commission shall return the reference if there is no prima facie case or proceed with the reference as a complaint if there is a prima facie case. 9. If the report of the Director General referred to in subsection 2 recommends that there is contravention of any of the provisions of this Act, and the Commission is of the opinion that further inquiry is called for, it shall inquire into such contravention in accordance with the provisions of this Act. The Commission is of the opinion that there exists no prima facie case, it shall close the matter forthwith and pass such orders as it deems fit and send a copy of its order to the central government or the state government or the statutory authority or the parties concerned, as the case may be. 3. The Director General shall, on receipt of direction under subsection 1, submit a report on his findings within such period as may be specified by the Commission. 4. The Commission may forward a copy of the report referred to in subsection 3 to the parties concerned, provided that in case the investigation is caused to be made based on reference received from the central government or the state government or the statutory authority, the Commission shall forward a copy of the report referred to in subsection 3 to the central government or the state government or the statutory authority, as the case may be. 5. If the report of the Director General referred to in subsection 3 recommends that there is no contravention of the provisions of this Act, the Commission shall invite objections or suggestions from the central government or the state government or the statutory authority or the parties concerned, as the case may be, on such report of the Director General. 6. If, after consideration of the objections and suggestions referred to in subsection 5, if any, the Commission agrees with the recommendation of the Director General, it shall close the matter forthwith and pass such orders as it deems fit and communicate its order to the central government or the state government or the statutory authority or the parties concerned, as the case may be. 7. If, after consideration of the objections or suggestions referred to in subsection 5, if any, the Commission is of the opinion that further investigations is called for, it may direct further investigation in the matter by the Director General or cause further inquiry to be made by in the matter or itself proceed with further inquiry in the matter in accordance with the provisions of this Act. 8. If the report of the Director General referred to in subsection 3 recommends that there is contravention of any of the provisions of this Act, and the Commission is of the opinion that further inquiry is called for, it shall inquire into such contravention in accordance with the provisions of this Act. Orders by Commission after inquiry into agreements or abuse of dominant position 27. Where after inquiry the Commission finds that any agreement referred to in Section 3 or action of an enterprise in a dominant position is in contravention of Section 3 or Section 4, as the case may be, it may pass all or any of the following orders, namely, 25. 26. 8. Direct any enterprise or association of enterprises or person or association of persons, as the case may be, involved in such agreement, or abuse of dominant position, to discontinue and not to re-enter such agreement or discontinue such abuse of dominant position, as the case may be, b. Impose such penalty, as it may deem fit which shall be not more than 10% of the average of the turnover for the last 3 preceding financial years, upon each of such person or enterprises which are parties to such agreements or abuse. 42. Provided that in case any agreement referred to in Section 3 has been entered into by a cartel, The Commission may impose upon each producer, seller, distributor, trader or service provider included in that cartel, a penalty of up to 3 times of its profit for each year of the continuance of such agreement or 10% of its turnover for each year of the continuance of such agreement, whichever is higher. 43 C. Omitted by Competition Amendment Act, 2007 D. Direct that the agreements shall stand modified to the extent and in the manner as may be specified in the order by the Commission. E. Direct the enterprises concerned to abide by such other orders as the Commission may pass and comply with the directions, including payment of costs, if any. 44 F. Omitted by Competition Amendment Act, 2007 G. Pass such other 45 order or issue such directions as it may deem fit. 46 Provided that while passing orders under this section, if the Commission comes to a finding that an enterprise in contravention to Section 3 or Section 4 of the Act as a member of a group as defined in Clause B of the explanation to Section 5 of the Act, and other members of such a group are also responsible for, or have contributed to, such a contravention, then it may pass orders, under this section, against such members of the group. 42 Subs. By Competition Amendment Act, 2007 4. Provided that in case any agreement referred to in Section 3 has been entered into by any cartel, the Commission shall impose upon each producer, seller, distributor, trader or service provider included in that cartel, a penalty equivalent to 3 times of the amount of profits made out of such agreement by the cartel or 10% of the average of the turnover of the cartel for the last preceding 3 financial years, whichever is higher. 43 Prior to omission, Clause C of Section 27 read as under. Award compensation to parties in accordance with the provisions contained in Section 34. 44 Prior to omission, Clause C of Section 27 read as under. Recommend to the central government for the division of an enterprise enjoying dominant position. 45 Subs. By Competition Amendment Act, 2007 4. Order. 46 Ins. By Competition Amendment Act, 2007. 2747 Subs. By Competition Amendment Act, 2007 4. Central Government, on recommendation under Clause F of Section 27 inches 48 prior to omission, Clause D of subsection 2 of Section 28 read as under. The payment of compensation to any person who suffered any loss due to dominant position of such enterprise. 49 Ins. By Competition Amendment Act, 2007 Division of Enterprise enjoying dominant position 28 1. The 47th Commission may, notwithstanding anything contained in any other law for the time being in force, by order in writing, direct division of an enterprise enjoying dominant position to ensure that such enterprise does not abuse its dominant position. 2. In particular, and without prejudice to the generality of the foregoing powers, the order referred to in subsection 1 may provide for all or any of the following matters, namely, a. The transfer or vesting of property, rights, liabilities or obligations, b. The adjustment of contracts either by discharge or reduction of any liability or obligation or otherwise, c. The creation, allotment, surrender or cancellation of any shares, stocks or securities. 48 D. Omitted by Competition Amendment Act, 2007 E. The formation or winding up of an enterprise or the amendment of the Memorandum of Association or Articles of Association or any other instruments regulating the business of any enterprise. F. The extent to which, and the circumstances in which, provisions of the order affecting an enterprise may be altered by the enterprise and the registration thereof. G. Any other matter which may be necessary to give effect to the division of the enterprise. 3. Notwithstanding anything contained in any other law for the time being in force or in any contract or in any memorandum or articles of association, an officer of a company who ceases to hold office as such in consequence of the division of an enterprise shall not be entitled to claim any compensation for such cessor. Procedure for investigation of Combination 29. 1. Where the Commission is of the 49 prima facie opinion that a combination is likely to cause, or has caused an appreciable adverse effect on competition within the relevant market in India, it shall issue a notice to show cause to the parties to combination calling upon them to respond within 30 days of the receipt of the notice, as to why investigation in respect of such combination should not be conducted. 28501A. After receipt of the response of the parties to the combination under subsection 1, the Commission may call for a report from the Director General and such report shall be submitted by the Director General within such time as the Commission may direct. 2. The Commission, if it is prima facie of the opinion that the combination has, or is likely to have, an appreciable adverse effect on competition, it shall, within 7 working days from the date of receipt of the response of the parties to the combination, 51 or the receipt of the report from Director General called under subsection 1A, whichever is later, direct the parties to the said combination to publish details of the combination within 10 working days of such direction, in such manner as it thinks appropriate, for bringing the combination to the knowledge or information of the public and persons affected or likely to be affected by such combination. 3. The Commission may invite any person or member of the public, affected or likely to be affected by the said combination, to file his written objections, if any, before the Commission within 15 working days from the date on which the details of the combination were published under subsection 2. 4. The Commission may, within 15 working days from the expiry of the period specified in subsection 3, call for such additional or other information as it may deem fit from the parties to the said combination. 5. The additional or other information called for by the Commission shall be furnished by the parties referred to in subsection 4 within 15 days from the expiry of the period specified in subsection 4. 6. After receipt of all information and within a period of 45 working days from the expiry of the period specified in subsection 5, the Commission shall proceed to deal with the case in accordance with the provisions contained in section 31. 52. Procedure in case of notice under subsection 2 of section 653(30). Where any person or enterprises has given a notice under subsection 2 of section 6, the Commission shall examine such notice and form its prima facie opinion as provided in subsection 1 of section 29 and proceed as per provisions contained in that section. 50 ins. By Competition Amendment Act, 2007 51 ins. By Competition Amendment Act, 2007 52 subs. By Competition Amendment Act, 2007 4, Inquiry into Disclosure under subsection 2 of section 6 inches 53 subs. By Competition Amendment Act, 2007 4, where any person or enterprise has given a notice under subsection 2 of section 6. The Commission shall inquire, a. whether the disclosure made in the notice is correct, b. whether the combination has, or is likely to have, an appreciable adverse effect on competition. Orders of Commission on certain combinations 31. 1. Where the Commission is of the opinion that any combination does not, or is not likely to, have an appreciable adverse effect on competition, it shall, by order, approve that combination including the combination in respect of which a notice has been given under subsection 2 of section 6. 2. 3. Where the Commission is of the opinion that the combination has, or is likely to have, an appreciable adverse effect on competition, it shall direct that the combination shall not take effect. Where the Commission is of the opinion that the combination has, or is likely to have, an appreciable adverse effect on competition but such adverse effect can be eliminated by suitable modification to such combination, it may propose appropriate modification to the combination to the parties to such combination. 4. The parties, who accept the modification proposed by the Commission under subsection 3 shall carry out such modification within the period specified by the Commission. 5. If the parties to the combination, who have accepted the modification under subsection 4 fail to carry out the modification within the period specified by the Commission, such combination shall be deemed to have an appreciable adverse effect on competition and the Commission shall deal with such combination in accordance with the provisions of this Act. 6. If the parties to the combination do not accept the modification proposed by the Commission under subsection 3, such parties may, within 30 working days of the modification proposed by the Commission, submit amendment to the modification proposed by the Commission under that subsection. 7. If the Commission agrees with the amendment submitted by the parties under subsection 6, it shall, by order, approve the combination. 8. If the Commission does not accept the amendment submitted under subsection 6, then, the parties shall be allowed a further period of 30 working days within which such parties shall accept the modification proposed by the Commission under subsection 3. 9. If the parties fail to accept the modification proposed by the Commission within 30 working days referred to in subsection 6 or within a further period of 30 working days referred to in subsection 8, the combination shall be deemed to have an appreciable adverse effect on competition and be dealt with in accordance with the provisions of this Act. 10. Where the Commission has directed under subsection 2 that the combination shall not take effect or the combination is deemed to have an appreciable adverse effect on competition under subsection 9, then, without prejudice to any penalty which may be imposed or any prosecution which may be initiated under this Act, the Commission may order that 29. 38. The acquisition referred to in Clause A of Section 5, or B. the acquiring of control referred to in Clause B of Section 5, or C. the merger or amalgamation referred to in Clause C of Section 5, shall not be given effect to, provided that the Commission may, if it considers appropriate, frame a scheme to implement its order under this subsection. 11. If the Commission does not, On the expiry of a period of 210 days from the date of notice given to the Commission under subsection 2 of Section 6 pass an order or issue direction in accordance with the provisions of subsection 1 or subsection 2 or subsection 7, the combination shall be deemed to have been approved by the Commission. Explanation. For the purposes of determining the period of 210 days specified in this subsection, the period of 30 working days specified in subsection 6 and a further period of 30 working days specified in subsection 8 shall be excluded. 12. Where any extension of time is sought by the parties to the combination, the period of 90 working days shall be reckoned after deducting the extended time granted at the request of the parties. 13. Where the Commission has ordered a combination to be void, the acquisition or acquiring of control or merger or amalgamation referred to in Section 5, shall be dealt with by the authorities under any other law for the time being in force as if such acquisition or acquiring of control or merger or amalgamation had not taken place, and the parties to the combination shall be dealt with accordingly. 14. Nothing contained in this chapter shall affect any proceeding initiated or which may be initiated under any other law for the time being in force. Acts taking place outside India but having an effect on competition in India. 32. The Commission shall, notwithstanding that, a. An agreement referred to in Section 3 has been entered into outside India, or b. Any party to such agreement is outside India, or c. Any enterprise abusing the dominant position is outside India, or d. A combination has taken place outside India, or e. Any party to combination is outside India, or 54 subs. By Competition Amendment Act, 2007. 4. 90 working days from the date of publication referred to in subsection 2 of Section 29 inches 55 subs. By Competition Amendment Act, 2007. 4. 90 days. F. Any other matter or practice or action arising out of such agreement or dominant position or combination is outside India, have power to inquire. 56. In accordance with the provisions contained in Sections 19, 20, 26, 29 and 30 of the Act, into such agreement or abuse of dominant position or combination if such agreement or dominant position or combination has, or is likely to have, an appreciable adverse effect on competition in the relevant market in India. 57. And pass such orders as it may deem fit in accordance with the provisions of this Act. 58. Power to issue interim orders. 59. 33. Where during an inquiry, the Commission is satisfied that an act in contravention of subsection 1 of Section 3 or subsection 1 of Section 4 or Section 6 has been committed and continues to be committed, or that such act is about to be committed, the Commission may, by order, temporarily restrain any party from carrying on such act until the conclusion of such inquiry or until further orders, without giving notice to such party, where it deems it necessary. 5657 5859 ends. By the Competition Amendment Act, 2007 ends. By the Competition Amendment Act, 2007 subs. By the Competition Amendment Act, 2007 4. Power to grant interim relief, subs. By the Competition Amendment Act, 2007 4. 1, 2, 3. Where during an inquiry before the Commission, it is proved to the satisfaction of the Commission, by affidavit or otherwise, that an act in contravention of subsection 1 of Section 3 or subsection 1 of Section 4 or Section 6 has been committed and continues to be committed, or that such act is about to be committed, the Commission may, by order, grant a temporary injunction restraining any party from carrying on such act until the conclusion of such inquiry or until further orders, without giving notice to the opposite party, where it deems it necessary. Where during the inquiry before the Commission it is proved to the satisfaction of the Commission by affidavit or otherwise that import of any goods is likely to contravene subsection 1 of Section 3 or subsection 1 of Section 4 or Section 6, it may, by order, grant a temporary injunction restraining any party from importing such goods until the conclusion of such inquiry or until further orders, without giving notice to the opposite party, where it deems it necessary, and a copy of such order granting temporary injunction shall be sent to the concerned authorities. The provisions of Rules 2A to 5, both inclusive of Order 39 of the First Schedule to the Code of Civil Procedure, 19085 of 1908, shall, as far as may be, apply to a temporary injunction issued by the Commission under this Act, as they apply to a temporary injunction issued by a civil court, and any reference in any such rule to a suit shall be construed as a reference to any inquiry before the Commission. 31. 326034. Omitted by the Competition Amendment Act, 2007 39 of 2007 with effect from the 12th October 2007, appearance before Commission 35. A 61 person or an enterprise or the Director General may either appear in person or authorize one or more chartered accountants or company secretaries or cost accountants or legal practitioners or any of his or its officers to present his or its case before the Commission. Explanation. For the purposes of this section, a chartered accountant means a chartered accountant is defined in Clause B of subsection 1 of Section 2 of the Chartered Accountants Act, 1949 38 of 1949, and who has obtained a certificate of practice under subsection 1 of Section 6 of that Act. B. Company Secretary means a company secretary as defined in Clause C of subsection 1 of Section 2 of the Company Secretaries Act, 1980 56 of 1980, and who has obtained a certificate of practice under subsection 1 of Section 6 of that Act. C. Cost Accountant means a cost accountant is defined in Clause B of subsection 1 of Section 2 of the Cost and Works Accountants Act, 1959 23 of 1959, and who has obtained a certificate of practice under subsection 1 of Section 6 of that Act. D. Legal Practitioner means an advocate, vacal or an attorney of any high court, and includes a pleader in practice. 60. Prior to omission, Section 34 read as under. Power to award compensation 1. Without prejudice to any other provisions contained in this Act, any person may make an application to the Commission for an order for the recovery of compensation from any enterprise for any loss or damage shown to have been suffered by such person as a result of any contravention of the provisions of Chapter 2, having been committed by such enterprise. 2. The Commission may, after an inquiry made into the allegations mentioned in the application made under subsection 1, pass an order directing the enterprise to make payment to the applicant of the amount determined by it as realizable from the enterprise as compensation for the loss or damage caused to the applicant as a result of any contravention of the provisions of Chapter 2 having been committed by such enterprise. 3. Where any loss or damage referred to in subsection 1 is caused to numerous persons having the same interest, one or more of such persons may, with the permission of the Commission, make an application under that subsection for and on behalf of, or for the benefit of, the persons so interested, and thereupon, the provisions of Rule 8 of Order 1 of the First Schedule to the Code of Civil Procedure, 1908 5 of 1908, shall apply subject to the modification that every reference therein to a suit or decree shall be construed as a reference to the application before the Commission and the order of the Commission thereon. 61 subs. By Competition Amendment Act, 2007 for, complainant or defendant. 3362 subs. By Competition Amendment Act, 2007 for 1. The Commission shall not be bound by the procedure laid down by the Code of Civil Procedure, 1908 5 of 1908, but shall be guided by the principles of natural justice and, subject to the other provisions of this Act and of any rules made by the central government, the Commission shall have powers to regulate its own procedure including the places at which they shall have their sittings, duration of oral hearings when granted, and times of its inquiry. 2. The Commission shall have, for the purposes of discharging its functions under this Act, the same powers as are vested in a civil court under the Code of Civil Procedure, 1908 5 of 1908 while trying a suit, in respect of the following matters, namely, a. Summoning and enforcing the attendance of any person and examining him on oath. B. Requiring the discovery and production of documents. C. Receiving evidence on affidavits. D. Issuing commissions for the examination of witnesses or documents. E. Subject to the provisions of Sections 123 and 124 of the Indian Evidence Act, 1872, 1 of 1872, requisitioning any public record or document or copy of such record or document from any office. F. Dismissing an application in default or deciding it ex parte. G. Any other matter which may be prescribed. 3. Every proceeding before the Commission shall be deemed to be a judicial proceeding within the meaning of Sections 193 and 228 and for the purposes of Section 196 of the Indian Penal Code 45 of 1860, and the Commission shall be deemed to be a civil court for the purposes of Section 195(2) of 1974 and Chapter 26 of the Code of Criminal Procedure, 1973. 4. The Commission may call upon such experts, from the fields of economics, commerce, accountancy, international trade or from any other discipline as it deems necessary, to assist the Commission in the conduct of any inquiry or proceeding before it. 5. The Commission may direct any person, a. to produce before the Director General or the Registrar or an officer authorized by it, such books, accounts or other documents in the custody or under the control of such person so directed as may be specified or described in the direction, being documents relating to any trade, the examination of which may be required for the purposes of this Act. B. To furnish to the Director General or the Registrar or any officer authorized by it, as respects the trade or such other information as may be in his possession in relation to the trade carried on by such person, as may be required for the purposes of this Act. 6. If the Commission is of the opinion that any agreement referred to in Section 3 or abuse of dominant position referred to in Section 4 or the combination referred to in Section 5 has caused or is likely to cause an appreciable adverse effect on competition in the relevant market in India and it is necessary to protect, without further delay, the interests of consumers and other market participants in India, it may conduct an inquiry or adjudicate upon any matter under this Act after giving a reasonable oral hearing to the parties concerned. Power of Commission to regulate its own procedure 62(36). 1. In the discharge of its functions, the Commission shall be guided by the principles of natural justice and, subject to the other provisions of this Act and of any rules made by the central government, the Commission shall have the powers to regulate its own procedure. 34. 2. The Commission shall have, for the purposes of discharging its functions under this Act, the same powers as are vested in a civil court under the Code of Civil Procedure, 1908-5 of 1908 while trying a suit, in respect of the following matters, namely, a. Summoning and enforcing the attendance of any person and examining him on oath, b. Requiring the discovery and production of documents, c. Receiving evidence on affidavit, d. Issuing commissions for the examination of witnesses or documents, e. Requisitioning, subject to the provisions of Sections 123 and 124 of the Indian Evidence Act, 1872, 1 of 1872 any public record or document or copy of such record or document from any office. 3. The Commission may call upon such experts, from the fields of economics, commerce, accountancy, international trade or from any other discipline as it deems necessary to assist the Commission in the conduct of any inquiry by it. 4. The Commission may direct any person, a. To produce before the Director General or the Secretary or an officer authorized by it, such books, or other documents in the custody or under the control of such person so directed as may be specified or described in the direction, being documents relating to any trade, the examination of which may be required for the purposes of this Act, b. To furnish to the Director General or the Secretary or any other officer authorized by it, as respects the trade or such other information as may be in his possession in relation to the trade carried on by such person, as may be required for the purposes of this Act. 6337. Omitted by the Competition Amendment Act, 2007-39 of 2007 with effect from the 12th October 2007, 63 prior to omission, Section 37 read as under. Review of orders of Commission. Any person aggrieved by an order of the Commission from which an appeal is allowed by this Act but no appeal has been preferred, may, within 30 days from the date of the order, apply to the Commission for review of its order and the Commission may make such order thereon as it thinks fit, provided that the Commission may entertain a review application after the expiry of the said period of 30 days, if it is satisfied that the applicant was prevented by sufficient cause from preferring the application in time, provided further that no order shall be modified or set aside without giving an opportunity of being heard to the person in whose favor the order is given and the Director General where he was a party to the proceedings. 35. Rectification of Orders 38. 1. With a view to rectifying any mistake apparent from the record, the Commission may amend any order passed by it under the provisions of this Act. 2. Subject to the other provisions of this Act, the Commission may make a. An amendment under subsection 1 of its own motion, b. An amendment for rectifying any such mistake which has been brought to its notice by any party to the order. Explanation. For the removal of doubts, it is hereby declared that the Commission shall not, while rectifying any mistake apparent from record, amend substantive part of its order passed under the provisions of this Act. 64. Execution of orders of Commission imposing monetary penalty, 6539. 1. If a person fails to pay any monetary penalty imposed on him under this Act, the Commission shall proceed to recover such penalty, in such manner as may be specified by the regulations. 2. In a case where the Commission is of the opinion that it would be expedient to recover the penalty imposed under this Act in accordance with the provisions of the Income Tax Act, 1961-43 of 1961, it may make a reference to this effect to the concerned income tax authority under that Act for recovery of the penalty as tax due under the said Act. 3. Where a reference has been made by the Commission under subsection 2 for recovery of penalty, the person upon whom the penalty has been imposed shall be deemed to be the assessee in default under the Income Tax Act, 1961-43 of 1961, and the provisions contained in sections 221 to 227, 228A, 229, 231 and 232 of the said Act and the second schedule to that Act and any rules made thereunder shall, in so far as may be, apply as if the said provisions were the provisions of this Act and referred to sums by way of penalty imposed under this Act instead of to income 64 subs. By Competition Amendment Act, 2007 4, Execution of Orders of Commission, 65 subs. by Competition Amendment Act, 2007-4. Every order passed by the Commission under this Act shall be enforced by the Commission in the same manner as if it were a decree or order made by a High Court or the principal civil court in a suit pending therein, and it shall be lawful for the Commission to send, in the event of its inability to execute it, such order to the High Court or the principal civil court, as the case may be, within the local limits of whose jurisdiction, a. In the case of an order against a person referred to in subclause E or subclause B or subclause B of clause L of section 2, the registered office or the sole or principal place of business of the person in India or where the person has also a subordinate office, that subordinate office, is situated, b. In the case of an order against any other person, the place, where the person concerned voluntarily resides or carries on business or personally works for gain, is situated, and thereupon the court to which the order is so sent shall execute the order as if it were a decree or order sent to it for execution. Tax and sums imposed by way of penalty, fine, and interest under the Income Tax Act, 1961, 43 of 1961, and to the Commission instead of the assessing officer. Explanation 1. Any reference to subsection 2 or subsection 6 of section 220 of the Income Tax Act, 1961, 43 of 1961, in the said provisions of that Act or the rules made thereunder shall be construed as references to sections 43 to 45 of this Act. Explanation 2. The Tax Recovery Commissioner and the Tax Recovery Officer referred to in the Income Tax Act, 1961, 43 of 1961, shall be deemed to be the Tax Recovery Commissioner and the Tax Recovery Officer for the purposes of recovery of sums imposed by way of penalty under this Act, and reference made by the Commission under subsection 2 would amount to drawing of a certificate by the Tax Recovery Officer as far as demand relating to penalty under this Act. Explanation 3. Any reference to appeal in Chapter XVID and the second schedule to the Income Tax Act, 1961, 43 of 1961, shall be construed as a reference to appeal before the Competition Appellate Tribunal under Section 53B of this Act. 6640. Omitted by the Competition Amendment Act, 2007, 39 of 2007 with effect from the 12th October 2007, 66 prior to omission, Section 40 read as under. Any person aggrieved by any decision or order of the Commission may file an appeal to the Supreme Court within 60 days from the date of communication of the decision or order of the Commission to him on one or more of the grounds specified in Section 100 of the Code of Civil Procedure, 1908-5 of 1908, provided that the Supreme Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within a further period not exceeding 60 days, provided further that no appeal shall lie against any decision or order of the Commission made